If you are an Indian family living in Texas, then you worked hard to build a good life for yourself and for your kids. But someday something will happen, and the question becomes, how do you plan to transfer these assets to your kids? Now, there are three ways in which you can transfer assets to your kids, should something happen to you. The third way to do it is you do nothing. You just don't have a plan in place. Then what happens? When you don't have a plan in place, what happens is Texas has a default estate plan that is already codified in a law called the Estates Code in Texas. So if you don't do anything, then the law will determine who will get how much of your share and how your property is to be divided up. And a court will follow that particular law. Now, the law may not necessarily reflect your wishes. So if you fail to plan or have a plan in place, most likely what will happen is the government already has one for you and a court will just apply that particular plan for you. The bottom line is option number 3 is not a very good option because your legal heirs will have to go through something called probate court, and they will have to determine who the legal heirs are, which could be a slow and expensive process. So option number 3, not a great idea. Let's take option number 2. Option number 2 is you can set up a will. A will basically captures your wishes as to how property will be transferred after your death and who will get which specific properties and the other balance properties in what proportion it should be distributed. And importantly, a will also talks about if you have minor children, you can appoint guardians through the will. In a will, you also appoint someone called an executor. An executor is basically a person who pays your debts, who pays your taxes, and then distributes the assets in accordance with your wishes to your children or to whoever you've left the assets to. But even with a will, your family would still have to go through probate court, which would include court costs, attorney costs, and so on. The entire process can be slow, it could be fast, it could be expensive, it could be cheap. It depends on a lot of factors. So even if you write a will, your family still has to go through probate court, and the speed and the expense depends on several factors. In my opinion, one of the biggest downsides or disadvantages to a will is that the probate court record becomes a public record. That basically means that anybody in the public will be able to access the court records, and they will be able to know how much your kids have gotten, how much money they have or how much they have inherited. So if there is any predator out there looking to target kids, or if your kids ever unfortunately have to go through a bad divorce, or if they ever have to get sued, they could lose all that just because it is in the public record, and that is accessible to everybody. And I think that's one of the biggest downsides of a will. And also, it's a court process, so it's basically you're giving a forum for anybody to come and challenge the will and question what your wishes actually were. Option number 1 is that you set up something called a revocable living trust. Think of a trust like a box. It's basically a box in which you can put all kinds of properties. You can put your home, you can put your vacation home, you can you can put real estate, you can put movable property, you can put gold, you can put business interests, you can put stocks, you can put any kind of assets in the box. And the advantage of having that box is that any properties or interests in that box will avoid probate. So it will avoid the probate court altogether, which makes it much easier for your family to access the properties that are in the box or in the trust that you have created. A trust generally has 3 parties. It has the grantor, which is you. You are the person who's making the trust. You are the person who's granting the trust. So you are the grantor. You have the trustee. The trustee is the person who holds legal title to the assets of the property in the trust. Now, during your lifetime, you will be the trustee. And the third party is that they will be a beneficiary, and during lifetime, your lifetime, you'll also be the beneficiary, which basically means you're playing all three roles during your lifetime. You are free to revoke the will, you are free to revoke the trust. You can change it, amend it, you can do whatever you want with it during your lifetime. Now, after you pass away, you appoint successor trustees who will then step into your shoes and distribute the assets in accordance with the wishes that you have put in the trust document. The biggest benefit, is that it provides privacy, it provides speed, and there's not much court involvement when you're transferring assets from yourself to your children. So, as a closing tip, get a plan in place so that it will help your family, it will help your kids, it will save them from stress, especially at a time when they need help the most. Follow for more estate planning tips for Indian families in Texas.